Wills and prenups are for peasants and slaves. The elites of this country use private trusts. And if you want to do the same, this video is going to go over how you can get out of the paradigm of enslavement and into one of freedom and prosperity. So the first thing to tackle is, why do people even get prenups and wills in the first place? So a will and a prenup, these are both written agreements that dictate what happens to a corpus of assets should something happen to the person. So in the case of a will, if it's the death of that person, and in the case of a prenuptial agreement, it's, when that person marries another person, there's some kind of agreement as to what assets and, what's going on as far as the split of that. So the first thing with both of these agreements, a lot of people do them because lawyers tell them to. And that's really the first thing that you have to realize. If you're watching this and if you're familiar with anything else on this channel, I often talk a lot about how lawyers lie. And not just that, but lawyers are statutory agents of the matrix. So anytime you go to advice from a lawyer, they're going to give you a set of instructions that keep you tied to the matrix under their bar license in a statutory nature. And so both wills and prenups fundamentally are statutory contracts because they're dealing with the assets in a person's name. So what is a person? A person is not a human being, but it's a business entity, and we're all given one at birth. We're all given our person, straw man, 9-digit social security number. So the first mistake that people make when doing a will or a prenup is that they have assets in their name when they're going into that arrangement. And so now they're writing out an agreement on how to deal with it. But here's the key. Why did you have assets in your name in the first place? So the idea is, if you don't have any assets in your name, then guess what? There's no prenuptial agreement needed and there's no will needed because you have nothing. And that's part of what this game is. Instead of holding assets in your name and then creating these documents, which are like peasant documents that then, tell the courts, what to do with your assets, the better thing to do is not have any of your stuff go to and be dealt with in the court system in the first place. So how do we do that? By taking them out of the public statutory matrix and putting them into the private realm under private trust law. So all the elites in this country use private trusts. Donald Trump uses them. All the billionaires use them. And you know that for a fact because when Trump files a tax return that has $750 on it, he's clearly a billionaire. He clearly has assets in a lot of different pockets. And many of them he doesn't even know because they're probably blind trusts. But the fact is that trusts are how the elites control assets without having the liability of ownership. If Trump owned all those things in his name, do you think he would have paid $750 in taxes or whatever arbitrary amount they came up with? Absolutely not. It could have been millions. But it wasn't, because he controls his assets in a way that is smart because he knows the law. And so people who are dumb will listen to lawyers and they'll keep stuff in their name, and then they'll write an agreement as to what should happen to that, should something happen to them. Or in the case of a marriage, should that marriage dissolve? But now, in both those instances, it's not efficient for a number of reasons. One, now you have to deal with state law and, again, all these different statutory layers that have to do with each of these documents. And so there's just so many variables to consider when that happens, especially when it comes to prenups. Prenups are broken all the time, especially depending on what the given state laws are. So why even have stuff in your name? Let's say, you're about to go into a marriage and you have all these assets and, you don't want the other person to necessarily just be able to sweep that and get half of it. So the very simple thing is you take it out of your name. So when you enter into that relationship, that marriage, now you can enter with nothing weighing your soul down. So you go in with nothing. So there's nothing to take from you. You might still control things in private trust, but guess what? Only the trustee of those trusts will ever have access to it. No court will ever break open a trust and give those assets to someone else other than the trustee. It just never happens. So you could now enter a marriage and have zero worry of anything because you don't own anything and all your assets are in trust. And the same thing with a will. A will is basically telling the court what to do with all these assets so you can avoid probate, which is terrible. Probate is where the court just decides what to do with your assets, and they take a massive chunk along the way just for doing that. So in both of these scenarios, rather than have the courts even involved at all, if you have all your assets and all your affairs outlined in a private trust, the trust documents themselves can take care of your affairs. So let's say you pass away. Now you have a trust where you were trustee of that trust, but you passed away. So there's several things might happen. You might have a board, in which case your board members would immediately already be in place, and there would be certain rules as to what would happen should this trustee pass away. So really the trust would keep running as is because the board would already have control without your absence, and they would just keep doing what they're doing. But let's say you're the sole trustee on a trust. In that case, you might have a successor trustee. So then they would step into place and they would deal with all the affairs of the trust, and they would also manage your end of life affairs. So, things to do with power of attorney, all these affairs that a will would normally take care of, all of that can be put inside the documents of a private trust. And all that is, the private trust is a templated set of documents, but once that trust is set up in the trust book, that is where the trustee or board of trustees on an ongoing basis will manage that trust and decide, what's happening with affairs. And in the case of a trustee, they might decide what's happening with their personal affairs as well. So again, a trust, if it's set up correctly, will completely eliminate the need for a will and completely eliminate the need for a prenup. So if you want to be smart about your affairs, don't listen to lawyers. Get your private trust set up. So you can check out the link in the description below or in the bio in the Bulletproof Retirement community. And in there, we have all the relevant links you'll need to set up your own private trust and get started down that route. So I look forward to seeing many of you in there, and I'll see you all in the next one.